coming. The regular meeting tonight, we'll be discussing the Holt 81 Randalls Road special permit for an area variance.
I can get us started with some questions.
You can get it started, Diane.
Sure. For the record, my name is Rob Stout. I am the ZBA attorney. As the chair mentioned, this is an application for several area variances in connection with 81 Randalls Road. Because these are area variances, ultimately a public hearing will be required. So the ultimate action that I think the board will be in a position to take by the end of this meeting is to schedule a public hearing for its next meeting on the area variances, at which time it could then consider the substance of the area variance. Tonight, I have a few questions. I want to make sure that we clarify the scope of precisely what area variances are being requested. Typically, after the meeting, Judy and I work together then to put together a public notice for the hearings so we can precisely identify in the notice what the relief requested is. And then they're free to go back to the planning board because there are planning board approvals that are required in connection with this as well. So my first question at a high level, one of the predicates to ZBA action is compliance with SECRA, and there was a short environmental assessment form provided in the application materials here. I noticed in the memo from John Andrews to the planning board dated April 7th, 2025, there was a suggestion that a coordinated review be commenced with the planning board as lead agency. John noted that this action does not appear to rise or fall within the threshold associated with a type 1 action. Nevertheless, there are multiple boards involved here, and it was their recommendation for the planning board to classify the action as an unlisted action subject to a coordinated review and declare their intent to be lead agency. I agree with that recommendation. That avoids multiple boards having to make individual SECRA findings on their own. It's the cleanest way to do it. It's not required by law because it's not a type 1 action, but it's just a matter of good practice. So I'm not sure, do we know if the planning board has done that? Maybe the applicant's representative can come
To
up.
my knowledge, they have not done that yet.
Okay.
This is our second step.
Yeah.
Please state your name.
Good evening, yes, absolutely. My name is Pedro Marmolejos. I'm representing the Holtz. I'm with Shelter Design Architecture. And to my understanding is that this is our second meeting here with the town. We first went before the planning board and they recommended we come here for two variances, and this is our second step. So the action you described has not commenced yet.
Okay. I believe the planning board's next meeting on Wednesday, right, Judy? I'll talk to Paul, who's my colleague, who's the planning board attorney. I would recommend that they use that opportunity to declare their intent to be lead agency and start the circulation. That way you really don't lose any time from it happening tonight if it happens 2 nights from now, and then you avoid both boards having to do SECRA on their own. You might want to give a brief overview of what's being requested, and then
Sure.
I'll have some questions.
I can do that, absolutely. So as I said, my name is Pedro Marmolejos. I'm representing the Holtz. They are the owners at 81 Randalls Road. They have been in Amenia for a while, and they love living here, and they see themselves as continuing in the community for a long term. They want to continue to reside their family here and make room for their 2 boys and their families. So we're proposing an extension to the existing house to make it a multi-generational house. The current residence there is an existing non-conforming structure. It is non-conforming because the lot and the residence both predate the zoning resolution that requires a minimum lot size of 5 acres and a front yard setback of 40 feet for residential use in an RR district. We submitted a site plan, as discussed, for an extension, but they, assuming under the following zoning sections that an extension to a conforming use or to any portion of a non-conforming structure shall not be deemed an extension of the non-conforming structure, so we thought that would be acceptable. Any lot of record created before 2007, which does not comply with the area, density, or dimension requirements, shall be deemed to comply with such requirements, and no variance shall be required for its development or addition. So under those 2 proposals, we thought we were on firm ground, but the planning board thought that we would still need a requirement, in particular 2 different variances. One is a minimum lot size variance, waiving or reducing the minimum lot size requirement from 5 acres to the lot size of the lot of record. And the second variance would be the front yard setback, which We believe that in the process of this extension, we can reduce the nonconformance, which is currently about 33 feet. Currently, the setback is 33 feet, 40 is required. We think we can reduce that to about 37 by reworking the front porch and pulling the house further away from the road. So we respectfully request that the lot size and front yard setbacks be waived along those lines, waiving it from 5 acres to 3.5 and from 40 feet to 37 feet. We think that in granting these variances, we don't believe that it is an undesirable change to the neighborhood. It would not be a detriment to the nearby properties, as it would be consistent with the existing residential character. We're not introducing a new use. We're continuing the residential use. Several of the adjacent houses currently have average square footages similar to what the house would be in its extended state. The front yard setback, we cannot improve any further than 37 without compromising the foundations of the principal structure, and it would be cost prohibitive to pull back any further. We have currently several applications in process for the environmental requirements, and to date, DOH and DEC have both approved our septic, well, and wetland strategies. So, and number 5, this difficulty was not self-created, as the property was historically residential before the zoning resolution, and it is only because of the zoning resolution that it is now limited in its development. That concludes.
Okay, I guess I'll just back up to the area where you had indicated you had initially thought, or the applicant had initially thought they were on solid ground, just to talk through that to make sure we all understand. And that cited provision was 121-27D. That says the extension of a conforming use to any portion of a non-conforming structure shall not be deemed the extension of a non-conforming structure or use. My read of that is that if you have a conforming use, which you do, there's no dispute that the use is conforming, and that if you're merely expanding that into a portion of an existing non-conforming structure, then the code doesn't deem that an extension of a non-conforming structure or use. What's happening here is a little bit different than that, and you're actually constructing a new portion of the building. My thought is that this didn't line up precisely what you're doing because there was an actual expansion involved. So that's one. It's not fatal, it just kicks us over into the realm of potentially needing an area variance. Which also brings into play 121-28A specifically, which I read, and by the way, nothing I say tonight represents a finding of the board or the final word on any issue, just thinking out loud so that we can have all the information in front of us. 121-28A, I read as an exemption from the need to get an area variance in certain instances. Where it says, any lot of record created prior to January 1, 2007, which we think this is, which does not comply with the area, density, or dimensional requirements of this chapter, which is an issue we have because the lot's undersized and we have a front yard setback issue, shall be deemed to comply with such requirements, and no variance shall be required for its development or for any addition to or other alteration of a structure, provided that the following conditions are satisfied. It also says a lot which satisfies the small-scale development requirements of 121-23 shall not be subject to the requirements below. And item 1, the following minimum area and dimensions are maintained unless smaller dimensions are permitted in the district. A, lot area, 8,000 square feet. B, front setback, not less than 30 feet from the center line of the road. C, side setback, 20% of lot width, but not less than 8 feet per side. D, rear setback, 15% of lot depth, but not less than 25 feet. 2, all health department regulations are satisfied. 3, and we'll talk about this one more. Any residential use of such a non-conforming lot shall be limited to one single-family dwelling. Non-residential uses, if allowed in the zoning district, shall be permitted as if the lot were conforming. And 4, within the SR district, a lot containing 40,000 square feet or more shall be treated as fully conforming and shall not be subject to the setback and use restrictions contained in subsection A1. We're not in the SR district. The board's engineer, in his April review letter, indicated that pursuant to 121-28A3, any residential use on a non-conforming lot is limited to a single-family dwelling. The accessory apartment, which is proposed as part of this, is not permitted, likely requiring an additional variance from the ZBA. I think this section creates some ambiguity, but I don't think it necessarily requires an additional variance. As I stated at the beginning, I read this as an exemption from the requirement to otherwise have to get an area variance for the things that an area variances are being sought for tonight. To the extent that the use involved is a residential use that's something other than a single-family dwelling, the applicant might not be able to take advantage of this exemption and therefore would still need to get the otherwise applicable area variances. I say there's ambiguity because the language says any residential use of such a non-conforming lot shall be limited to one single-family dwelling. So we refer then to the definition of single-family dwelling to find out the scope of that. Dwelling single-family is defined as a detached building designed for the use of one family in which not more than 3 boarders are sheltered and/or fed for compensation. There's no reference here in the definition to an accessory apartment or accessory structure. There's also in 128A3 that I read before, no reference there to an accessory apartment or accessory structure being permissible in order for the applicant to enjoy this exemption from the area variance requirement. That said, there is another section of the code that the applicant pointed out. In the general earlier portions of the code and the land use district regulations, with respect to the section 121-12 dealing with multiple and accessory dwellings, which says that accessory apartments and accessory, the title is accessory apartments and accessory residential structures. One accessory apartment per attached or detached single-family dwelling may be located in an accessory structure or a principal building as provided in the land use table. So the land use table allows an accessory apartment or accessory structure. The ambiguity, I think, is that 128A3 doesn't clearly say that that section modifies this, that a single-family dwelling in addition to an accessory apartment is allowed. That would entitle you to this exemption from the requirement to get an area variance. I can see arguments on either side. I think something for the board to consider, and we can talk about this more as time goes on, is whether or not the simple, more conservative approach is to simply eliminate that ambiguity and go ahead and treat this as a request for area variances pursuant to the balancing test that the applicant's representative just went through. So I put that out there for something for the board to think about. I don't know if you have any perspective on the issue.
You've hit the nail right on the head. So we thought we were, the accessory apartment would be considered part of whatever the definition of a single-family residence would be because of the 121.12C. It clearly puts accessory apartments in single-family dwellings. What gave us a little more confidence that it wouldn't be an area issue tied necessarily to a lot size was where it continues to say that it shall not be counted as a residential unit for purposes of determining density. So in no way does the accessory apartment increase the residential density on the lot. So it would still be a single-family residence, even though it has what could be interpreted as another dwelling unit, right, inside the house. It's still a single-family dwelling with an accessory apartment, no change in density. That said, like as you said, the town engineer had a slightly different take, and he thought that we still needed an area variance to be more sure about the minimum acreage requirement for the lot, because I believe his conclusion was actually that although it is existing residential use on the site now and has been historically, the residential use itself he considered non-conforming, not a conforming use. We thought it was conforming because it was historically grandfathered in, but because it didn't meet the minimum acreage requirement, he thought that residential use was non-conforming.
Well, the minimum acreage requirement, and I can talk to him about this a little bit more. I have discussed this briefly with him. There could be a distinction between the dimensional requirements in the form of the acreage requirement and the actual use. But I understand the residential use is expressly permitted, correct?
Well, yes, it is in an RR district, absolutely.
Yeah.
It is permitted, in this specific case, it's been there historically. Were one to develop a 3-acre lot in RR, they would not be allowed to put residential on it.
Got you.
Today, I mean, post 2007.
And that's as a result of the dimensional table?
Yes, let me just get it in front of me so I can be sure, but yeah, that is, I believe there is a minimum 5-acre requirement in
Right.
RR. Yes, 5-acre, yeah.
I see the point relative to the density language you cited. Again, arguments could be made on either side. I still lean towards the more conservative approach, being just go ahead and do the variance tests. The applicant has provided you with the information you need in order to make that balancing test. That's something that'll be done at the next meeting. I can confer further with the board's engineer on that and produce an updated recommendation letters before that meeting, so we have something to act on. Just want to go on here in this letter. We get into the enumeration of the requested variances. The first one for minimum lot size. I didn't quite follow the narrative description where we say we respectfully request a variance modifying the minimum required acreage for residential use on this property to be reduced from 5 acres to the size of the lot of record. But follow that. As a conforming residential use, an expansion of its floor area beyond 50% would not require a special permit. Now, the special permit is what's required, not from this board, but from the planning board. And that's due to language in 121.27, non-conforming user structures and lots, where the code says, a non-conforming use or structure shall not be extended, enlarged, or structurally altered except as provided below. The extension of a conforming use to any portion, I read this earlier, the extension of a conforming use to any portion of a non-conforming structure shall not be deemed an extension of a non-conforming structure or use. Subsection 2. The planning board may issue a special permit allowing an expansion of a non-conforming use or structure by up to 50% of its area at the time of the adoption of this chapter, provided that all other requirements can be met and that such expansion does not reduce any non-conforming setbacks by more than 20%. Expansion or introduction of uses prohibited by 121.10C shall not be permitted. Now, as I read this, we're not reducing any non-conforming setbacks by more than 20%. In fact, we're increasing a non-conforming setback. We're reducing the non-conformance. I read this to say that the structure that you're expanding cannot be expanded by more than 50% of its area at the time of the adoption of the chapter, which goes back to 2007. So reading that sentence again, as a conforming residential use, an expansion of its floor area beyond 50% would not require a special permit. So I didn't quite follow that. Are you expanding it more or less than 50%?
No, I think there might have been something wrong with the way perhaps my syntax.
Yeah.
So we request the variance modifying the minimum required acreage. Once that minimum required acreage is lowered, thus as a conforming residential use, we would be able to expand more than 50%. In other words, if the variance is granted, then we can expand more than 50%, because now the use for the increase above 50%.
Increasing
I don't have the math in front, but more than 50%, yeah.
It's like 4,200 square feet, right?
Yeah, it's 4,000 or so, yeah. And I think the existing house is currently 1,000 something.
More than 1,500.
Yeah.
Some change.
That's something we can take up with the planning board as to whether or not, if you assume this board issues an area variance, then it then obviates the need to get a special permit because it renders the lot conforming. I think the fact will remain that the lot is still undersized, even though this board has issues an area variance presumably to allow the lot to continue to be undersized. But that's not an issue for this board, so we can set that point aside.
Yeah, so just to be clear, we understand that the lot will remain undersized, but that undersizing, we've been told makes the residential use non-conforming.
Okay.
So if residential use can be conforming on the site via this variance, that's what we're seeing. We understand that the lot will continue to be undersized, but we want the residential use to be a conforming use.
Okay. Got it. Okay, that helps clarify my understanding of the point there. My other question with respect to the area variance number 2 was the reference to reducing the setback from the required 40 feet to 37 feet.
Yeah.
I had looked at John's letter as well as the plans, and I saw a reference to 32 and a half feet. Are we reading that incorrectly? Or, I'm sorry, 33.7 being the existing
Correct.
setback, going to 32, but it sounds like that's not the case based on the reference to 37 feet?
Yeah, no, if you look in your packet, we're trying to make the setback 37.2 by modification of the existing structure. The drawing is labeled 7B.
Can we put that up on the screen? Is that the drawing?
No, that's not it. It was part of the ZBA package. This is the planning board submission.
Is it I have an A001, A200.
No, it's before that. It's part of the, it's right behind the map showing the location of properties within a quarter mile.
OP-1?
No. 7B, it looks like this.
7B,
It's B, yeah.
yeah, 7B.
7B. yeah.
7B.
It's a letter size sheet.
See that here, Rob?
There you go.
Ah, okay.
You just had one more page to turn.
Yeah,
It was probably the next one, yeah.
yeah, it was. So I'm sorry, what are we looking at?
So I'm sorry, so on 7B, there are two drawings. The top drawing is the existing plan and its relationship to the center line of road. Currently, the area in red is what is non-conforming with the 40-foot front yard. As you can see, the setback currently is 33.7 feet from the center line of the road. We're proposing as part of this extension and in the process of construction to reduce that non-compliance by reconfiguring the entry, kind of working it without compromising the foundations too much, and bringing it to 37.2 feet from the road. So that is, the non-compliance is lessened as part of this application.
Aren't you increasing it if it's closer to the road?
It will be less close to the road. Drawing number 1 at the top of the page is its current condition.
Uh-huh.
Drawing number 2 at the bottom of the page is the proposed condition, where there
I
is,
see.
yeah.
I see.
Yep.
So the 32 feet was simply an error in the review letter?
I think so, well, yeah, I think so. Let me see, because that,
Just wanted to make this one.
Because I'm looking at drawing OP1, and I do see where
I think that's it.
2.5-story wood frame building appears to be,
OP1, that's on the civils drawing?
yeah.
Okay, hold on. Yeah, so, oh, I see, oh, yeah, okay, so, we would not propose that architecturally. Our request for variance is we would be aiming to reduce that non-compliance.
Gotcha, okay,
Yeah.
all right, so that's not operative at this point? Okay, so that answers that question. I don't have any more questions at this point, unless the board does of the applicant.
Any questions? George? Any questions?
No.
Craig?
Well, one question is, so you want to have the setback at 37 feet, right?
Yeah.
Now, that would bring the house closer to the road, right?
No.
I mean, make it, would that increase that, or
No, so
keep it the same?
that the FEMA lot line adjustment is another thing that, sorry, the FEMA letter of map amendment is another track here. The
extension.
currently, the special flood hazard area just nicks the northeast corner of the proposed extension. By way of elevation, where the creek is running and the elevation, the final habitable elevation of the proposed extension, we will be well above potential flood areas. And so we've given this geometry and these elevations to FEMA for review to get a letter of map amendment to basically update or edit the FEMA line, because
On the other side of the red
the
line.
geography of it, the topography really puts it outside the flood area. That's at the rear of the house. In the front of the house, we're reconfiguring the current entry and porch area
That's.
to pull away from the front yard setback. The porch that we are proposing to be the new
This is
entry,
the red line.
Yes, I know.
coming
Well,
to
In other
you.
words, you're right, it is.
Yeah.
We'll ask him, yeah,
Yeah.
sorry.
the porch that we are performing is an open porch, and those are permitted to enter the front yard setback up to a point.
And I think that's the issue, that there was a side conversation here, because on a new structure, the stairs appear to be at least partially in front of the 40-foot line. And is that exempted from the setback requirement you were just saying?
It's part of the open porch, so open porches and stairs are exempted from the 40-foot front yard.
If they were not exempted, do you have a sense of how, they look to be at least 37.2 feet back, if not more?
If not more, yeah, but I mean, we could also look into a different, yeah, I think that, particularly on the extension, we could probably find a different geometry to make it work.
I thought this was the open porch.
That was.
What
Used
is,
to- used
what
to
is
be.
the other, what is the existing?
The existing mudroom, because it's not really, it's a door opening
It's
into
a
a mudroom.
mudroom?
It's an enclosed, yeah, it's enclosed
Okay.
architectural, yeah, it's part of the volume. But it's a part of the volume that we could potentially work out a way to remove to make the non-compliance less.
I have a question about the CEQA requirement. If we do it jointly with the planning board, how does that work? Do both boards vote? Do we have equal weight? Is it separate votes?
On the question of whether or not the project will have a significant adverse environmental
Yeah.
impact, which is different from the variance, that would be entirely handled by the planning board if they were lead agency, just as on any other matter where they're
So
lead
what-
agency.
What do we have to do with the CEQA?
Wait for the planning board to finish it. Nothing. What they will do, if they declare their intent to be lead agency at their meeting on Wednesday, they will circulate a package of the circulate an application package to all the interested and involved agencies. Involved agencies are any other agency that's issuing an approval, of which this is one. They will ask this board and all the other agencies, are you okay with us being lead agency? Do you have any objections, or would you prefer to be lead agency yourself? Typically, the board that's lead agency is the one that's has responsibility for the more significant approvals at stake here. It's probably the planning board, frankly, in this instance. So this board, and it usually is when there are planning and zoning board approvals involved. So what this board can do is respond by letter back to the planning board and say, nope, no objection, you guys go ahead. Or if this board doesn't respond in 30 days pass and the law provides that they're automatically lead agency, they can then issue their determination of significance. POSDEC requires the preparation of an environmental impact statement. A negative declaration concludes that the project will not have any significant adverse environmental impact, and seeker's over at that
So
point.
our view is only for the variances, really, we have nothing to do with deciding whether they need to do an environmental impact statement.
Correct. That said, this board is free to even if they're not lead agency, share their perspective on any questions on the environmental review to the planning board, to say, hey, guys, you really ought to look at X, Y, and Z, and then the planning board can take that into consideration in deciding,
Or not.
or not.
Thank you.
Thank you.
Any, Dave, any?
No, he answered my FEMA question.
Okay.
So I'll get with John, I'll make sure we're aligned on our view of what's being requested here. If we have any further questions, we'll reach out to you directly. Assuming not, Judy and I will work on a notice for a hearing for the August meeting, which is, do we know the date of that meeting?
18.
I won't be here.
Might be a good time to ask if enough people will be around with
I won't be
Yeah.
here.
vacation
When?
schedules, August 18th?
I'm on vacation.
Yeah, I'll be here.
I'll be here.
Okay.
You'll be here.
Sounds like we'll have a
We,
quorum.
we got animals.
Yeah, so,
We're not going anywhere.
So then it would be appropriate for the board to motion to schedule a public hearing on the requested area variances for August 18th at 6 PM.
before you go on to do that, I talked to you briefly about that wetland area in the back. I know there's no regulations that I know of that are applied to this. But I was just, one of the things I was wondering was if that building was moved, just tilted slightly towards the road, which would put more of it in the setback area, would it reduce the wetlands area significantly so that they wouldn't have to contend with that? It's just a personal thing that might be something to consider.
The wetland line looks pretty far. I'm not sure where you are relative to the buffer. Do you want to address that?
Sure. We've been applying to DEC in parallel to this, and they've already given technical approval to the proposed. And this is where I'm going to get maybe mix up my technical terms, but the wetland mitigation strategies, the plantings and stormwater management, that has been technically approved. We're just waiting for these other approvals to kind of clear up before pulling the permits.
Okay.
So-
Well, what I was thinking, when I looked at, the first thing I looked at was the area in the wetlands
Yeah.
is quite large.
Yeah.
And it was like if they tilted that building or brought it forward just a bit,
Just as, it would be
you'd
further
still be
away.
getting a variance for the setback, but you might alleviate some of the problems with the wetland.
You're absolutely right. The geometry was such a way that we didn't want to hurt the front yard setback. We didn't want to make that an additional nonconformance. So because our civil engineer thought he had a good strategy for the wetlands mitigation, which seems to have proven so, we tried to comply with both. So DEC is okay with it, and we're not trying to make the front setback any worse. So.
Do you know if DEC, I'm sorry, has done their own secret determination? And
They have, it's been submitted as a minor action, type 2, and I can follow up with more detailed information, but we got a technical approval on June 9th.
Okay.
Is that piece there?
June 9th.
I just thought that
Can you just forward that to Judy? Yeah.
because the only thing I'm gonna be doing is.
I'll see if I'm sure there was a document issue. I got the email, so I'll see what I'll send you the information.
Alleviate some of
So
that,
our lawyer's saying it's a major
but
action.
it doesn't look like it does because.
Is there gonna be a problem?
I'll get back to you guys and see. My records say it's a type 2 minor action. but-
Yeah, just so we can have an understanding. It's not major, it's either type 1, type 2, or unlisted.
Yeah,
and,
that's right, that's right.
Actually, the application itself indicates it's unlisted, so just so we, be helpful to have an understanding as to why, for DEC perspective, it was
Absolutely.
unlisted, or type 2.
Will do. Thank you.
Okay,
I have nothing further.
you've got nothing further? So do we want to,
I vote that I move that we have a public hearing on what date?
August 18th,
August 18th,
Monday.
Monday at 6 PM.
do I hear a second?
I'll second that.
All in favor?
Aye.
Aye.
So carried.
And we did say 6 PM, right?
We did say 6 PM. And one of these days, I'm gonna change that.
To what?
What did you like?
5.
Oh, I thought you
A little later.
wanted to go back to 7, and I
No,
was like,
don't
oh,
go
no.
Maybe
No.
6:30.
Yeah.
Don't go back late. It's the winter time, it's terrible.
So, Rob, once again, explain if the planning board becomes the lead agency, does that negate a lot of our responsibilities?
Only
Except
with
for the
respect to
variance?
secra. It doesn't change the variance
Just-
criteria
okay.
at all.
Okay,
Timing-wise, we'll see whether or not the board will be in a position to actually vote at the conclusion of the public hearing on the 18th. And the reason why I say that is you're not going to meet again before the 18th. So, well, here's how we can handle that. You won't have the opportunity to respond as a board to the circulation that goes out on Wednesday in order to say, no, we're not interested in being lead agency. If that's the case, the planning board would have to wait. Do you know, when is the planning board's August meeting?
13,
Okay.
13 and 27. So the 27th is after your ZBA, the 13th is before your ZBA.
If the planning board finds himself in a position on August 13th to issue a negative declaration, and it does, this board could, if it wants to, consider and actually vote yea or nay on the area variances on the 18th. If the planning board is not complete with secra by then, this board can have the public hearing, but you can't vote on it until the planning board is done with secra. Because you're not meeting again until August 18th, you will not have the chance to respond to the planning board's circulation of its intent to be lead agency and say, give your consent to them being lead agency. What we can try to do tonight, see if the planning board is comfortable with it, is to have the board consider voting and telling the planning board prior to the circulation
We
that you
give
have no
our
interest,
consent.
that you're giving.
Yeah,
You've
can
seen
we-
the application material, so they'll be circulating the same application back to you. So I think it would be okay for you to tell the planning board proactively that you give them their consent to be lead agency.
I think that'd be a good idea.
So
Me too.
somebody can make that motion, and then Judy can convey that to the planning board Wednesday.
I'll make the motion that we give our consent for the planning board to be lead agency.
I second it.
All in favor?
I
I-
vote no.
You vote no,
No.
so 1 no?
Okay. So then that can be passed along. If there's, in terms of the no vote, if there's an issue that you think the planning board should consider, it would be, fine to mention that on the record now so that it could be provided to them. Or at any point between now and the planning board meeting.
Do you want to speak to that now, or?
It's totally up to anyone on the board. No one has to speak to it.
George, do you want to speak to that, or you just,
No, I don't want to give pre-approval of anything. I want them to make the decision, and then we decide afterwards whether or not we agree to them to be the lead agency. That's all. I'm
I
just
got
going
you.
on a principle.
Okay.
But
Lead agency is just the designation of who's going to.
just for secret.
Secret. So if the planning board does anything at their meeting on Wednesday, the only thing they would be doing is saying, it's our intent to be secret lead agency to conduct the environmental review. Other interested and involved agencies, please let us know if you object to that. They're not going to be considering the substance just yet of of whether or not a neg deck should be issued. They would be doing that on August 13th.
Yeah,
I mean, just on principle, I don't want to give away my leverage.
yeah.
But
But are we giving away
how are we
anything?
doing that?
I don't know. I just know that in the past, they've made negative declarations that have floored me.
Right, but then you can object to it.
Oh, I object to it, I object. Anyway, it's
Don't mean
fine.
that.
Yeah, you know, I vote no, and it's already passed, right? So there's no problem.
I mean, if this board also, just as a reminder to everyone, once we get into the substance of the area variance request, if there are conditions that are related to the variance that's being requested that could potentially mitigate the effect of the relief being requested, it's appropriate to think about and consider what those conditions are. Those issues remain within this board's purview.
That's what I thought.
Thank you. Would you like me to just address this? or-
Yeah.
Okay. The agricultural data statement lists 3 properties that are within, let's see, 500 feet of a farm operation. One of which is Craig's and 2 of which are Barbara Mealy. In terms of whether or not there's a requirement for a property owner, board member, excuse me, to recuse themselves from consideration of an application, there's no automatic requirement. We can't tell anybody they have to recuse themselves. That said, if any board member, and not just somebody who lives next door, any board member feels that they cannot fairly consider an application objectively, then a recusal is appropriate. And I have no idea whatsoever whether or not any member on this board has made any comment at all saying, yes, I think this should be approved, or no, I don't think this should be approved. But anybody who has indicated in any public forum that they might vote one way or another, that's something to think about in terms of whether or not it's appropriate to recuse yourself. We're not considering anything substantive at all tonight, so
Okay.
all the board members have an opportunity to think about this question over the course of the next month and then make their own decision as to
Okay.
what the appropriate action is.
Very good. We just needed to check it before.
We've been there before.
I know
What
that
we went gone
there
through
was a
before.
huge hullabaloo with myself over the last town topic, and I recused myself, and I was almost by force
Mhm.
from the opposing attorney. And I just think if you can take care of those things in the beginning, it
Right.
sometimes makes it a lot better farther down the line.
Yeah.
But it could,
I lost
think-
my voice
yeah.
as far as the
Yeah.
board goes, but it was the right thing to do for the town.
It could avoid the perception, even if no conflict or bias exists, it can avoid the perception and just make it easier for you. But again, there's no default rule that says if you live X feet away, you have to. So anyone who wants to talk to me individually over the course of the next month is certainly free to. You can talk amongst yourselves on that issue and let me know if there's any question.
Okay.
Okay, very good. And I would
Here the minutes.
take a look at the second thing on the agenda, which is the minutes from the ZBA special meeting, 4/28/25. Anybody got any comments? Corrections, additions?
I got some copies if anyone wants to see them if they have it.
I wasn't there.
Really?
You're right, you weren't.
Oh, it says you were though.
Hmm?
Guess I gotta change that.
Yeah.
All right.
I was there for the last part where we,
Oh, because you walked in at 7 o'clock.
yeah,
So you thought the meeting started at 7, not 6.
right.
So you were there.
Yeah,
I
shoot.
wasn't there. I was there for the,
So how do we record that? Just late,
I was
late
there.
arrival.
Yeah,
Okay, I'll change it to late arrival.
but I don't think you have any minutes involving.
No, no, no.
here.
No, that was an exec session, right.
I saw a couple of small
Agenda-
typos, but that was about it,
Little typos.
you know.
I'll look back and see if I can find them.
Other than that, I read it through and it met my approval.
And then I'll just say, given that it relates to the minutes and the issue that was removed from the agenda, The issue regarding the interpretation that was requested and discussed at that meeting, I talked to Paul, my colleague who advises the ZBA, and we both advise Mike as well. Those types of questions, the interpretation questions, should more properly go to the building inspector's office. They're the ones under the code that are charged with interpreting the building code. This board is charged with any appeals of those decisions. So I don't think tonight it's necessarily appropriate to go into a deep dive on the merits of any particular interpretation one way or the other. Those should be issued by the building department, and then if somebody appeals that, comes to this board, and then this board issues a determination. So
That's the Willows.
yes, yeah, it's, we don't want to be, this board shouldn't do anything that could appear to prejudge how it would act if somebody appeals a determination of the code enforcement officer's decision. This is the quasi-judicial function of the ZBA. You're essentially functioning like a court, reviewing certain things, and this is one of those instances where if somebody appeals, and to my knowledge nobody has yet, but if somebody does, you'd be sitting as a judge essentially in that matter.
Very good, thank you. I
So
think,
you like to approve the minutes as amended, if there's a motion, or you gonna?
I move that we approve the minutes as amended.
I'll see that. You can,
Who seconded it?
Craig,
Okay.
all in favor?
Aye.
Aye.
So moved. With that, I guess, the next thing is a request to adjourn. Anybody like to make a motion to adjourn this meeting?
Somebody else.
Yeah.
You
We
want to
all
stay here a
took
little
our
longer?
turn.
Did we do the public hearing?
Go ahead, Craig.
Yeah, you guys made that.
Did he move?
Yeah.
Yes.
Oh, you did. Do we have a second?
I second we adjourn.
Yeah.
All in favor?
Aye.
Aye.